Right, today I'm going to talk about the UK Constitution. We've looked at the Italian Constitution. For the Italian Constitution, there is one source of law, the Constitution, the written document. That is the source, and there's one organ which interprets that. That's the Constitutional Court. England is very different. The English Constitution isn't written. There are some written parts, but mainly it's common law, so it's not written. And there are many sources to the UK constitutional law. It's UK, not England. The UK constitutional law. For example, we've got authoritative writing. For this, an example of authoritative writing is Parliamentary Practice by Erskine May. This was a writer that wrote many books on the Constitution and the Parliament and how it works, and is considered a constitutional document. These documents are often written by experts and considered influential, so give indication. But they are not binding, they're non-binding. So no court recognises them in terms of being a law. The courts recognise laws, whether it's common law or which is a higher sentence, or a legal, something which is created as a law. It's been through the legal process and recognised as a law. So this is not. Another source of law is common law. These are sentences made by judges, and they are binding for lower courts. So if a judge in a maybe the High Court or the Supreme Court makes a judgment, for example, Europe, when we were in European Union, the European Union was recognised as being supreme. That was in a judgment, and that was recognised by other lower courts because the higher court had said that. But a court on the same level or even higher can change that. So that's not binding in the sense that, you know, a law is binding. That is, it can be changed, not totally secure. So, or the ordinary law. The ordinary law is a law made by Parliament, enacted by the Queen, and this is binding. And it must be, if we want to change it with another ordinary law, remember any law can be changed with another ordinary law, it must be explicitly said that this cancels this other law. So it's not implicit. Just by changing the law doesn't mean the constitutional laws before are changed. It must be explicitly stated that this is a change to the previous constitutional law. And it's supreme. We can say it's supreme, it's binding. Big problem with this is much of the Constitution isn't in the ordinary law. Much of the Constitution, in fact, is just conventions, just practice, just prassi, should we say. In Italian we call them prassi or consuetudini, where, you know, repeated habits over times. And these conventions, again, are not recognised as laws, so they're not recognised in the courts as being a law and having consequences, if, you know, punishment for not respecting them. They can change, they have changed over many years. There is the convention that the Queen must assent to the law, to any bill of Parliament that's been approved by Parliament. She must assent before it can become a law. this is a convention. But these things can change. Not that they will change, but over time they could. So these are not sure either. And like I said, it's not enforceable in the court. One of the most fundamental, unchangeable things, though, is in our constitution, is that Parliament is sovereign, and Parliament makes the law, and the Queen enacts that law. By assenting, she enacts the law. So that that is considered quite the most fundamental thing in our constitution. But we can see from our constitution that what is the constitution if it's not binding and much of it can be changed very easily. That's the big difference with the English constitution and the Italian constitution. Ours is much less certain and much more mobile, much more free, if you like. The fact that the Queen must assent to the law, that could change. That's just a convention. What would happen if we have a situation where we're not sure what the constitution is, because not much is said and it's not binding anyway. Maybe some experts would say one thing, the government must do this, and then other experts say no, the government must do that. So what happens in this case? This is what we call a constitutional crisis, when we reach a situation where we're not sure how to proceed, because there's no real solid constitution to follow. We're not controlled by a constitution. This is a constitutional crisis, and what happens is the powers of the day, be they in the Supreme Court or the government or the Parliament or whoever is involved in the situation, would have a kind of battle to try to prevail. Maybe the Queen's involved too. And there would be a battle for public opinion to try to get them, to have them on their side, etc., to prevail. So there is this possibility of a crisis and a bit of a battle for supremacy. The English have this characteristic of being very free, very uncontrolled, shall we say. Whereas the Italians, you don't. You have this constitution that controls everything, goes into every detail. So everyone needs to know how they react, or act, even to the detail of every public worker must do a concourse or must behave in a respectable way, or every worker must be paid a dignified wage, and every parent must educate and maintain the kids. So it goes into real detail, very clear, and controlled by one and interpreted by one organ. So it does feel like the constitution is controlling Italian life, whereas in England we have the feeling that nothing is in control ultimately. So we just see reality and are masters of our own destiny. We decide, look at our strengths and weaknesses and opportunities and threats, and decide a strategy and go for that strategy and see what happens. This uncertainty is built into our constitution. Now, for example, if the Queen refused to sign a bill, to assent to a bill, what would happen? This would be a constitutional crisis. to be recognised as a law, it is said that the Queen must assent to a law. Otherwise it's just a bill of Parliament. Maybe it's approved by Parliament, but it needs her assent. Why is that? Well, let's go into why that is. She is head of state. She is the boss of the state. Now, if, for example, there was no head of state, maybe the Parliament can make a law like, all Labour members of Parliament are to be banned from coming to Parliament or from voting in Parliament. Just one law would change us into a dictatorship. But we have this Queen who takes responsibility for that. And for that reason, she does play a good role as head of state, being able to say, this is a reasonable law and I will put my name to it. Remember, if she puts her name to something that is really a crime against humanity, she is also responsible for that. So we can see that as her role. But the courts really need to see her name there, because who's to say what is a law otherwise? A bill of Parliament that's approved by Parliament. I mean, what is Parliament? Maybe they had a vote and didn't invite half the members of Parliament to that vote. Maybe they've created a Parliament in a different building, having another secret vote or something. So just having one person verify, and that person being above the system, above the law. I mean, the Queen can't even be judged by an English or a United Kingdom court. So she is really super parts. So having that is actually useful and needed. But if she didn't put her name to I mean, if she decided not to put her name, there would be a bit of a, if it was a legitimate law, there would be a constitutional crisis, because it's not perceived that the Queen is political. If she does refuse to put her name to a law which taxes her, maybe that would create a lot of tension between her and the people, and then therefore Parliament eventually, or maybe the Supreme Court, etc. So this would create a tension. There would be a bit of a battle. Maybe those for against the monarchy could start arguing to abolish the monarchy. This would create a dynamic, wouldn't it? And that's how it works in England. We're looking, while people are fair and reasonable and playing a good role like the Queen, with her royal assent, people won't rock the boat. So what ain't broke, don't fix. Okay, that's a good English expression. It seems to work very well, so it won't be questioned. But if the Queen starts interfering in our democratic system, it will create a dynamic against and may ultimately lead to the downfall of the royal family. But we can see, the English can see a good role for the Queen and for the royal family. It does give us a feeling of connection with the past. Remember, Italy reached a moment where it had to start again. The king, the royal family, associated itself with terrible forces, the fascists, and you needed to start again, all sit down, create a pact between the different forces, and then make sure that pact is very clear so it doesn't happen again. We never reached that. We feel the history of our royal family. Our royal family gives us a connection to the past. It's a constitution that is evolved over time, changed over time very, very slowly. But there's a continuity to it. You know, the fact that a family is represents us, gives us a feeling of being a very natural community. The most natural community in the world is a family. Quite artificial community is a republic. You have to really construct it. People aren't really equal in that natural sense. Their status tends to fluctuate according to how they can project themselves. In England, we do have this difference of status. Maybe it's not fair, but it seems to work okay at the moment. This could change. Like I said, you know, we're very free and nothing is inevitable. Okay. In Italy, you do get a feeling of the situation, the culture is controlled by the constitution, and things are inevitable. They will go down this road because the constitution pulls us down this road a little bit. Not to the extreme. Yeah, the constitution does give us a lot of freedom to live, but does put limits to our behaviours, does discipline us a lot more than the English. Okay, so if we look at examples of different constitutional crises just with Brexit, there was one when Johnson prorogued Parliament. For example, he wanted to avoid a Brexit vote. We had a government that was Brexit and a Parliament which was generally Remain, and he wanted to avoid a vote on a bill calling for no deal. He wanted always to be able to threaten Europe with no deal, and he didn't want this vote on or even discussion. So he wanted to close Parliament for 3 weeks. He asked the Queen, and the Queen said yes, because only the Queen can close the Parliament. He was taken to the Supreme Court. The Supreme Court said, no, you can't. You can't close Parliament. He said, I'm going to do it anyway. This was a constitutional crisis. The Supreme Court has very little it could do if he closed it anyway. You know, Parliament can't be invaded by police, for example. There's not much laws that could. There's no laws that control Parliament. So he was going to do it anyway. And then the opposition, the Remainers, threatened to open a Parliament opposite, in the church opposite, and call it Parliament and make laws. And this would have been dangerous. This would have been, you would have a Remain Parliament and a Brexit Parliament. And civil war possibilities, because which laws would be recognised by the courts? So it would create a dangerous situation. In the end, he didn't. Another constitutional crisis was the government threatened to advise the Queen not to assent to the withdrawals treaty if it said there couldn't be a no deal, or it said something they didn't want. They were going to advise the Queen, and this would have been a crisis because the Queen listens to the government. The convention is she listens to the government, not the Parliament. So this would have been who is in control, the Parliament or the Queen and the government. And the Parliament represents the majority of the people. We would have had a dangerous situation for the Constitution again. Another situation is very unusual. The Speaker of the House of Commons decided that Parliament decides parliamentary business, not government. Parliamentary business is when we vote what we vote on in Parliament. So the government normally organises the diary. And they didn't want to allow a discussion on a no deal. So they weren't giving it time, parliamentary time. And the Speaker of the House of Commons, Burker, said, I change the constitution and allow the Parliament to decide parliamentary business. So he, one man, without any majority or anything, decided that Parliament would be able to decide when to vote and what to vote on, changing the constitution of Great Britain. So that shows how mobile our constitution is, and how uncertain, uncodified it really is. It really is a lot about power play. Who's gonna prevail? Who's in the position to prevail at any crisis?